Good afternoon, everyone. Welcome to the SAME DC Post April First Friday webinar. Again, my name is Whitney Stoll. I'll be your DC Post First Friday webinar host. And welcome back to our First Friday webinar series with our April First Friday with our guests Laura Breyer and John Neary from Polero Mazza presenting Don't Leave Money on the Table, Unlocking Federal Contract Disputes to Increase Cost Recovery. Also joining me are Bree Beal and Samantha Long, who are monitoring the chat and running the show from behind the scenes. So we have over 75 registered participants from all over the world ready to learn on today's First Friday webinar. So in today's webinar, the team from Polero Mazza are going to guide you through the federal contract disputes process, sharing practical strategies to strengthen claims, navigate appeals, and maximize your cost recovery on federal projects. But first, I'd like to welcome you all to our First Friday webinar series, which is provided to you through SAME's commitment to offering the AEC community effective training, development, and networking programs. The DC Post is helping sustain the future of the profession with these monthly education-focused sessions that are aligned with SAME's strategic goals to drive partnerships, deliver solutions, and develop people. So thank you all again for joining us here today as we start our program. Please feel free to use the chat to introduce yourselves, share your LinkedIn profile, and where you're joining us from today. Include your email for everyone and anytime throughout the program. Ask questions in the chat so we can address some during our Q&A portion at the end. We are using the Adobe Connect platform, so you can chat with everyone and send messages to our hosts, presenters, and even each other throughout today's webinar. So we are recording today's session and we will post a video on our YouTube channel later on. So a copy of your slides, your PDH certificate, and an opt-in list of attendees will be available to download at the end of today's webinar. And we also email you all a copy as soon as the webinar ends. So just look for an email labeled document delivery in the subject line with all your downloads following this webinar. So we're excited to provide you an hour of education, virtual networking, no matter where you're calling in from. So we'd like to take a moment to thank our DC Post First Friday sponsors, Fox Rothschild, JS Global, ATG, KCCT, Parsons, and Stantec. So we truly appreciate your support and we are grateful for your generosity by making this webinar series possible for our members and SAME community. So annual sponsorship is still available at the DC Post. And so now is your opportunity to support this webinar series as an annual sponsor and start using your sponsorship benefits throughout 2026. Annual Platinum sponsors and First Friday sponsors help support this webinar with free registration for SAME members and full-time students. So please visit our website for more information about sponsorship levels and how you can gain visibility for your company while giving back to your SAME community through your DC Post annual sponsorship. So now it's time for the main program. And please note this program will provide one professional development hour from the DC Post. I'm not going to read through the learning objectives since most of you saw these same objectives when you registered, and I'm going to introduce our featured speakers in just a moment. And if you haven't done so already, please use the chat to introduce yourselves, share some contact information, your LinkedIn profile, and where you're joining us from. This is your webinar series to learn more about the special topic as well as expand your business network throughout the program. We will answer all the questions from the Q&A chat at the end of the program. You will not be able to save the chat, so make sure you make any notes from everyone you want to connect with before the webinar ends. And now, please join me in welcoming Laura Breyer and John Neary to our DC Post First Friday webinar. Laura Breyer is a partner and chair of Polero Mazza's REA's Claims and Appeals Group, bringing extensive experience presenting government contractors in complex claims, appeals, and litigation before federal courts and boards. John Neary is an associate at Polero Mazza, advising government contractors on construction law, contract disputes, and regulatory compliance, drawing both from his legal background and prior experience as a contracts manager in the AEC industry. So, Laura, I'm going to turn this over to the team. I'm going to turn this over to you, and the floor is yours.
Great. Thank you, Whitney. And thank you, everybody, for joining us this afternoon. We really appreciate it. So we're going to talk about not leaving money on the table and how to unlock federal contract disputes to increase cost recovery. we have some bio slides here, but Whitney did a great job of introducing us, so I'm gonna actually skip through those and focus first on our agenda. So one of the things that John and I did, we tweaked this a little bit, more so than our just standard claims discussion, to focus more so on what we're seeing on the ground since the change in administration. So we're actually going to focus a little bit on stop work orders because we've seen a massive increase in stop work orders being issued across agencies at DoD and civilian based. And then we've also seen a massive influx of terminations for convenience and terminations for default. Those are dispute related. So we feel like the focus there is absolutely needed, particularly based off of what we're seeing from our client base. So that is going to be the initial focus of the discussion. And then we're going to get into constructive changes and the appeals process as it relates to claims. So we are covering claims issues today, but it's going to be a little bit more narrowly focused on what we're seeing since 2025. So hopefully that is helpful to everyone that is here this afternoon. So focusing first on stop work orders, what are they? So they are exactly what they say they are. They are instructions from a contracting officer to a contractor to stop work. So we saw a massive influx of these stop work orders when DOJ came in the door in early 2025, and unfortunately it has continued thereafter. The stop work order clause cited here is 52.242-15. And basically what it's saying is when you receive, as a contractor, when you receive a stop work order notice, you're required to stop work. The stop work order notice cannot exceed 90 days. But when it is received, what the contractor is required to do is obviously stop work and notify its subcontractors that they are also to stop work until that stop work order is either lifted or a termination is processed. So what we have been seeing happen is stop work order notices are being sent to contractors, oftentimes to give the agency time to evaluate whether this is a contract that they want to continue. So what we saw happen in early 2025 as DOJ came in the door, there were a lot of funding evaluations and assessments that are continuing to happen in 2026. Stop work order notices are being issued. It gives the government then some time to evaluate whether we want this work or not. And they're either lifting that stop work, I'd say within 30 days, or they're then exercising a termination for convenience, which is then a follow-on notice. But what are you required to do when you get that stop work? Again, you're supposed to stop work, you notify your subs, but it's also really important that you open negotiations with the contracting officer to allow for an equitable adjustment under the stop work clause. So that allows for you to recover costs associated with the stop work, as well as extensions of time under the stop work. So if you actually look up FAR 52.242-15, the contracting officer shall make an equitable adjustment. So they are arguably required to make an adjustment if the contractor is in fact incurring costs. What a contractor does have to do, though, is they have to make attempts to mitigate those costs while they are in a stop work posture. So what does that mean? If you are a contractor and you get a stop work notice, you obviously have to evaluate the impacts that it is going to have in your operations. So an example is, say you have a service contract, you're given a stop work notice, you have personnel on your bench. What do you do with those people? You have to mitigate. So you have to actually evaluate those personnel, understand, can I keep them on the bench or do I have to find other projects for them? What I would suggest is that you look to see if there are other contracts that you can put those personnel on. You may have to put them on leave, but you cannot just have them on the bench idling, incurring costs if there's a way to mitigate that situation. So that's absolutely something that you need to evaluate. The same thing happens with like equipment. If you have equipment in place and you could put that on another project, you cannot just let that cost incur. You actually have to mitigate the situation and try to see if there's useful purpose for that equipment somewhere else. So those are just some instances to take into account when calculating your costs on a potential adjustment. Another important practice point when receiving a stop work is that you, like I said, are entitled to seek adjustment through the REA process under the stop work order clause. Timing is extremely important. So under that clause, typically you are required to submit a request for equitable adjustment within 30 days from the lift of the stoppage. So again, say you get a stop work notice, it's put in place, 30 days later, the stop work gets lifted. You are then arguably on the clock to submit your request for equitable adjustment for the costs incurred within that 30-day period of stoppage. You can seek a reasonable extension. So, if it's something that you cannot do, you're still working with your subcontractors to understand their costs. My suggestion in that instance would be to reach out to your contracting officer, seek a reasonable extension to submit those costs. But again, keeping those lines of communication open with your contracting officer so that they are not surprised that you're actually going after the costs associated with your stop work. There is no required format because the adjustment request is through the REA process. There's no FAR clause that requires an REA to be in a certain form or fashion. But what we do suggest is that you obviously have supporting documentation for the cost that you are seeking or even the time that you're seeking, right? I mean, typically, if you receive a 30-day work stoppage, you're obviously arguing for a 30-day extension to be tacked onto your performance period. But as far as costs go, your any personnel costs, labor, equipment, lease facilities, anything like that, that all has to be supported with underlying documentation. You can't just say, hey, this is a spreadsheet table of the costs we incurred, government pay us for that. They're going to want to see the underlying documentation in your REA submission. So it's really important that you record that information as you're going through the stoppage period. Another important practice point is that you actually can recover attorney's fees and administrative costs associated with the work stoppage. So example, contractor gets a stop work notice. They reach out to me and John to understand their rights under the REA process to seek adjustment for the stop work. The time that we spend talking with you, that is recoverable time. Any time that we spend helping you through that proposal process, as far as that REA, that is also recoverable costs. As long as we're tracking our time, which we do, and as long as your team is tracking your time as well, that is recoverable costs. So what we typically tell clients is that if they get a stop work notice, immediately create a separate cost code so that you can actively record the time that you are spending working through the stop work clause, notifying subcontractors to stop work, placing people on other contracts. All of that time is recoverable as long as you assign a reasonable rate to it. So really important that you're tracking that time and potentially engaging counsel if you need it. There is unfortunately no required deadline for the government to respond to a stop work REA and really any REA in general. So that is something also to keep into account. Say your stop work costs are excessive, right? It's a cost you cannot carry for longer than 60 days. If that is the case, then you need to start considering whether you file that REA as a claim. So that's converting it from the REA process to a certified claim under the CDA, which I'm going to get into in a bit. So big picture, and this applies more generally in practice, not necessarily just to stop work orders. It also applies to termination proposals that John's going to get into a little bit. But these are just general practice points when you're deciding whether to submit a request for equitable adjustment or a certified claim under the CDA. But REAs are typically best suited for when there's plenty of time left on the contract. An REA from a higher level perspective is meant to be a negotiation process, right? It's amicable. You're working things through with the contracting officer. There's some push and pull, but you're not in an adversarial position yet. Then we're talking REA. Also, when there's plenty of time left on the contract for that negotiation process to pass through. The issues are not contentious. And in some instances, the contracting officer has actually said, hey, we'll talk through these costs, submit an REA, we'll work through it. Obviously, that's a position where you don't want to elevate to a claim just yet. Another benefit of being still in the REA phase and seeking adjustment through that process is that, again, you can include your legal fees expended on preparing the REA. Same with the administrative costs. So if your team is spending time putting together costs associated with a stop work or even some other issue like a change in scope, that time is a recoverable time. It can be included in the REA submission. So, just keeping that in mind, that is a benefit of just simply going through the REA process. A negative of the REA process, again, is if you have large costs associated with the REA that you cannot carry, there is no regulatory requirement for the government to respond to that REA. So, we have clients that submit REAs, they're out there for a year plus because, again, the government does not need to respond within a certain time frame. And primarily since the change in administration, we know that there's been a lot of rifts, there's been a lot of turnover on the government side. So there's been more delay as far as REA reviews and submissions. So that's something else to keep into account that maybe you're ready to file a claim, because there actually is a regulatory requirement for the government to respond to a certified claim under the CDA. So when a claim is really your best avenue of approach for seeking a cost or time adjustment is when first there's little time left on the contract. If the contract has ended, you are absolutely in claim posture at this point, because really an REA is meant to be submitted during performance and to be negotiated through while performance is ongoing. Claim is for really at the closeout process, because again, regulatory requirement kicks in that they have to respond within 60 days. So therefore, it speeds up the process, and a claim is the way to go when the contract is ended or is very close to being complete. Another reason for filing a claim versus an REA is when the issues are controversial or contentious. Say you've already submitted an REA and the government has basically said no in response. That's when we're talking claim. The government's already given you insight as to they're not willing to negotiate. So we are in a dispute posture. Therefore, filing a claim under the CDA is your best way to go. Again, once that claim gets submitted, contracting officer has 60 days to issue what's called a contracting officer's final decision. They do have leniency to seek a reasonable extension to respond to that submission. So they can ask typically within about 30 to 45 days of an extension. If you submit a massive claim, say we're talking millions of dollars with multiple supporting documentation, the government may ask for, a 6-month extension, which is often seen as reasonable because you have to give the contracting officer a legitimate period of time to review all of the underlying materials. It's hard to push up against a contracting officer's request for an extension unless it's per se unreasonable. Say they're asking for, for example, like a year to review. We would push back on that and say that it needs to be done sooner. But that is really where we're talking claim. You can no longer carry the cost. You're under a tight deadline to submit, or the issues are controversial. Big picture, though, for all of these issues, you have 6 years to submit a certified claim. So, and that is from when the issue arose. So say you have a contract, from 2019, and the issue spurred in 2019, we're looking at 2026. Arguably, you are too late to submit that claim to the contracting officer. So really important you understand that there is a 6-year statute of limitations requirement built into any type of claim. So, we have clients that reach out and say, well, my RA has been pending for 3 years. We're ready to convert it to a claim. But there was, a lot of time previous to that REA submission that passed, and the issue was, 6 years prior. Just because you submit an REA doesn't mean you preserved your rights under the statute of limitations. The only way to preserve that right to an adjustment of cost or time is through the claim process. So again, really important to understand that the 6-year statute of limitations applies to the claim process. Just because you submit an REA doesn't mean that tolls the statute of limitations. Another big point too, from the claim perspective, legal fees associated with putting a claim together, same with administrative time spent putting a claim together is not a recoverable cost. The reason being is that the government sees that as an adversarial position. So anytime that that your legal is spending on putting together the claim is not recoverable. REA is different because it's still seen as a negotiation and working in good faith between the parties. Claim, legal fees associated with putting that together are not recoverable. So just something else to keep in mind. All right, John, I will pass it to you.
All right, thanks, Lauren. So as Lauren mentioned, a lot of times the stop work orders translate into, or eventually.
John, I'm having issues with your audio. I think you lost sound, sorry.
Yeah. Okay, sorry about that. As I was saying, we saw a huge uptick in terminations for convenience over 2025. And I would say even the issue even became a little bit of a sub-practice group within our firm in terms of helping clients process these termination for convenience settlement proposals, which are provided to contractors or guaranteed to contractors through the FAR. Basically, a termination for convenience is the government's unilateral right to terminate a prime contract for any reason it would like other than a default reason, so a breach on the part of the contractor. So a lot of times this has to do with funding, which we've seen a lot over 2025, is stripping of funding from the contract and the project being worked on, which forces the agency to terminate the contract for its convenience. The nature of the settlement proposal that a contractor is entitled to recover may vary depending on the type of the contract. So there's FAR clauses specific to different contract types, which I'll get into in a second. Always look to the contract itself to see what kind of FAR clause is incorporated directly into the contract in terms of the termination clause. Sometimes we've run into issues where we've seen notices of termination that cite to a different termination clause than what is incorporated into the contract. And the contract will typically govern the contractor's right to recovery. So we typically rely on the FAR clause that is incorporated explicitly into the contract itself, but we'll point out the discrepancy between the FAR clause that's cited in the termination notice, if there is a discrepancy between the one that is incorporated into the contract. And sometimes it's actually to the contractor's benefit to cite to both FAR clauses being implemented for the termination. But usually we rely heavily on the one that is incorporated into the contract, as that's the one that's effective on that particular contract type. Contractors may need to convert a settlement proposal to a claim if there's an impasse between the government and the contractor in terms of settling the costs related to that termination. We, knock on wood, have been not seen too many of these, too many of the termination proposals being converted to claims. Ultimately, typically the government and the contractor have been pretty successful in eventually negotiating a settlement price. So once a contractor receives a termination notice, FAR clause 49.104 governs the prime contractor's obligations once it receives that termination notice. It outlines what the contractor is supposed to be doing once upon receipt of that notice. So I won't go through every bullet point here, but typically the prime contractor is generally required to stop all work, settle its subcontracts, which is an important step to mitigate any damages resulting to the subcontractors. As you'll see here in a second, the settlement with subcontractors can be incorporated as part of that settlement proposal. So it's the obligation of the prime contractor to immediately pass that termination down to its subcontractors and try to mitigate costs being incurred by any subs. The contractor is also required to protect and return government property within its control and begin preparing its settlement proposal. A lot of that is administrative time related to collecting evidence, timesheets, invoicing, evidencing the contractor's costs. So that can be, in some cases, a big task and take some time. So as soon as the contractor receives that notice of termination, it should start that process in order to prepare the settlement proposal. So as I mentioned before, different contracts typically incorporate different FAR clauses, which govern the contractor's right to recovery and also provide essentially the procedure for submitting a settlement proposal and negotiating that settlement proposal with the government. So here you'll see I list a few here. There's a termination under a firm fixed price contract, which we've seen recently overlap with other types of contracts. So it may be a firm fixed price construction contract. It may be a firm fixed price services contract. There's a short form clause for services contract. Cost reimbursable contracts have a separate clause, and commercial items terminations as well. So again, you may see an overlap on occasion of some of these clauses, but typically they're distinct and incorporated into the appropriate contract type. Yeah, so again, I would say pay attention to the FAR clauses that are incorporated into your particular contract. Look to that FAR clause in terms of what costs are reimbursable to the contractor and how those costs are supposed to be presented. And sometimes there are standard form requirements that a contractor is obligated to fill out and submit to the government in connection with the settlement proposal. That may vary based on the type of FAR clause that is being implemented. So just some things to think about when, as soon as you receive that notice of termination, look to the FAR clauses that are cited in that notice of termination, then go back to your contract and double check the FAR clauses that are incorporated into the contract itself, just to make sure there's no discrepancy. So here I've listed a few of the unpaid costs or costs that are typically reimbursable under a T4C settlement proposal. So unpaid costs are generally allowable and recoverable. And some examples of these are direct costs on labor and materials, settlement expenses, which are expenses specifically related to preparing and submitting the settlement proposal. So these are expenses that would fall outside of the contract price. So that would be administrative accounting fees if a separate accountant is working to prepare and organize the costs. Those fees would be included. Legal fees for any legal help or advice that's being contributed to the settlement process, whether that's preparing a settlement letter or advising the contractor on appropriate fees that can be sought through the settlement proposal. And then as well as termination settlements with subcontractors, which I mentioned before. So if there's any claims by a subcontractor or there's outstanding balance on subcontracts, those can be also pursued under the settlement expenses. So the claim cost should generally be allowable and allocable to the contract and reasonable. So what that means is essentially the government will look for adequate evidence in support of the costs. So we encourage contractors to be as organized and as transparent as possible when submitting settlement proposals, providing, again, timesheets, invoices, any sort of correspondence that may help evidence costs that were incurred maybe at the government's direction and that were not otherwise paid under the contract. A contractor does need to mitigate damages. Again, that's part of once you receive that stop work notice, once you receive the termination notice. If you had not received a stop work notice before that, upon receipt of that termination notice, that's when all work should be stopped, and that's when a contractor should start taking note of outstanding costs on that contract and preparing for the settlement proposal. So that's the mitigation of the damages that would be incurred following a termination for convenience. Okay, and then we're switching gears here a little bit, but I'd like to take a moment to talk about constructive change. We've seen, we've helped a few contractors process constructive change arguments and theories of recovery. This would be applicable to REAs. We see these a lot in construction and design build sort of contracts. And what that is most contractors are familiar with changes clauses. Again, similar to a termination for convenience clause. Each contract type typically has its own changes clause that would generally be incorporated into that specific contract type. Again, there may be some overlap in terms of firm fixed price, making it into other sorts of contracts. or various forms of contracts. But typically, you would see a distinct changes clause. What a constructive change is it's regardless of the applicable FAR clause, an acting contracting officer may unilaterally change the terms of a contract without issuing a formal written order. So the formal written order is what you would typically see under the changes clause. But the boards have upheld the precedent that contractors may still be entitled to equitable adjustments in their contract price for informal directives by contracting officers or point of contacts with authority within the agency directing the work of the contractor to make changes to the contract. And a lot of times what this comes in the form of is a negligent or unreasonable interpretation of the specifications of the contract. So for instance, a contractor under the constructive changes doctrine could argue that the contracting officer's interpretation of a specification or denial of the contractor performing a contract in a certain way that was appropriate under the contract's terms essentially led to a change to the contract, right? It changed their method of performance. It required them to change the method of performance and incur additional costs that were not anticipated under their contract. So we've seen a lot of success in arguing the constructive change doctrine as, again, specifically related to construction-related contracts. But I just wanted to bring that to everyone's attention because it's a recovery theory that is applicable to the REA and claims process and is not explicitly set out in the FAR clause, but is rooted in a changes clause, which would be incorporated into the contract.
All right, thank you, John. I'm going to jump back in here and just talk about some practical warnings, including waivers and reservation of rights. So one of the things that you need to keep in mind, just operating in the federal space is modification from the government is not something that you have to sign as is. If it's a bilateral agreement, obviously unilateral agreement is what it is. But if there is some bilateral modification that you are receiving, and for instance, you know that you have costs and you just haven't gotten around to submitting an REA or even a claim, and you get a subsequent modification from the government, either to potentially close out or resolve a certain issue of performance, you absolutely have to make sure that you are reserving your rights to any potential costs or already incurred costs that you just, again, have not sought adjustment for in that modification. So the government automatically almost always includes some form of waiver or release in contract modifications, which typically blanketly releases them from any liability for any action or inaction prior to the mod. So again, if you know that you have incurred costs that you want to seek in the form of an adjustment, whether that's an REA or a claim, you can actually go into that modification and strike language, make modifications, and send that back to the contracting officer for negotiation. We do that for clients all the time. You should not feel like you have to sign that modification. At the end of the day, it is obviously a business decision, right? You have to weigh your temperament with the contracting officer, understanding that this could be a challenge, and weigh, potential loss of those costs. If you have incurred costs, again, that you need through some adjustment process, you have to weigh the balance between, okay, is it worth us signing this mod as is, or should we push back and see if we can strike some of this language or put some form of reservation of rights in this mod so that we feel comfortable in its execution? So again, really important to understand your rights and that it's not something that you have to sign. It can be modified and negotiated through with the government if it is a bilateral requirement. Okay, we're going to talk a little bit about appeal rights as well. I know that we're a little short on time, so I'm going to move a little fast. As far as appeal rights, so say you submit a certified claim based off of a stop work order REA converting to a claim, a termination for convenience proposal converting it to a claim, a constructive change REA converting it to a claim, anything that's converted to a claim that receives a contracting officer's final decision. So again, going back to what we talked about, that 60-day requirement for the contracting officer to issue a decision. Once you get that contracting officer final decision, what do? So you do, say it's a partial denial or a full denial, you have the right to appeal that decision. So that appeal can typically go to either one of two forums. So it's either the Board of Contract Appeals or the Court of Federal Claims. If you're dealing with a Postal Service or FAA specific contract, they have their own boards that, operate and oversee claim appeals. But more likely, you're either going to the Armed Services Board of Contract Appeals that oversees DoD specific contracts, or the Civilian Board of Contract Appeals that oversees civilian contracts, or alternatively, you can go to the Court of Federal Claims. When you get a contracting officer's final decision, it should lay this out for you. It's going to lay out your appeal rights under the FAR, and it's basically going to say you can either appeal within 90 days to the Board of Contract Appeals, or you can appeal within 12 months to the Court of Federal Claims. But it is important to understand that once you pick a forum, that you are stuck there. You cannot then shift to the other forum. Say you get a judge you don't like at the Board of Contract Appeals, you are stuck there. You cannot then remove that case and go to the Court of Federal Claims. The other importance is understanding the distinction between the two forums. So what we typically tell our clients is that it's preferable to go to the Board of Contract Appeals, and there's a few reasons why. One of the reasons, it's a little less formal than going to the Court of Federal Claims. Administrative law judges sit over the board. Their discovery requirements are a little less demanding than going to the Court of Federal Claims. And one of the other big benefits is that the administrative law judges that sit on the board at the Armed Services and at the Civilian are typically retired government contract attorneys, so that they are well steeped in the FAR. They understand federal contracts and the ins and outs of federal contracting that helps them provide a more independent analysis of certain disputes. If you are going to the Court of Federal Claims, it's a grab bag of judges in the sense that some judges have IP backgrounds, some have patent backgrounds, some have limited federal contracting background. So you may get a judge that doesn't really fully understand the FAR, and you spend a decent amount of time really educating the judge on some of these issues. The other distinction between the two is, if you are appealing to the Court of Federal Claims, the Department of Justice steps in and represents the agency in that context. And because of that, DOJ oftentimes is less inclined to discuss alternative means of resolution early on in the process, because they do have to spend some time working with agency counsel to get spun up on the issues. When we appeal to the Board of Contract Appeals, sometimes there's more of a willingness to negotiate an off-ramp, whether versus going through protracted litigation. Because the agency is represented by its own attorneys, they're a little bit more privy to what's going on the ground as far as the dispute. So there's some benefits there as well. Both forums offer alternative dispute resolution processes, but again, there's more inclination to exercise those processes at the Board of Contract Appeals earlier in the process than at COFC. One other thing to note that has become actually more relevant since the change in administration is the use of the judgment fund. So when false claim penalty payments are made, that's just one example. It goes into the kind of this big bucket of money that agencies can use to pay out judgments ruled against them. So some contracting officers in this case and agency attorneys in this case, since we've been receiving so many terminations for convenience, a lot of the agencies don't have the funds to actually pay these termination for convenience proposals out. So what they've actually been instructing some of our clients is actually to file a claim for their termination for convenience, so that they can then pay that claim out on appeal through the judgment fund. So it is being used more prevalently since 2025. Something to keep in mind, that the contracting officer may ask you to go through the proper procedures so that they can then access the judgment fund, versus actually having to go to their superior within the agency to try to get more funding, which has been a big trip up for a lot of agencies, again, given the cost restrictions imposed by the new administration. And I will kick it back over to John really quick. John, just heads up, we only have 4 minutes. So if you can get through this quickly, that would be great.
Yeah. So the Civilian Board of Contract Appeals and the Armed Services Board of Contract Appeals release reports every year, basically providing statistics on kind of what they're seeing in terms of how many cases are being appealed to those boards, what the resolution rate is in terms of briefing resolution before the case goes to, or the appeal goes to a hearing, or Rule 11 briefing, which is Rule 11 is where contractors or the parties have the ability to agree to resolve the matter through briefing rather than going to a hearing. So each board provides kind of a status update on what they saw during the prior year at the end of each year, and these are just some statistics. I won't go through all the numbers, but I'll leave it up there for a second to let everyone kind of glance over them and some changes that happened between 2025 and 2024. I will point out that the CBCA appeals before the CBCA had outweighed arbitrations in 2025, which was a switch from 2024. That indicates that parties are opting to litigate rather than engage in ADR or another form of settlement negotiations. So just an interesting point, something to consider. Usually the reason for that is that the parties believe that a resolution would be more fair or more accurate based on litigation rather than going to ADR. CBCA also saw an influx in disputes involving the VA in 2025. Of the 222 appeals filed in the CBCA, 70 involved the VA, so approximately nearly one third. All right, and then here's a similar slide just for the ASBCA, and there's 95 more ASBCA appeals filed in 2025 than in 2024, and that's the most ASBCA has seen since 2022. So an influx of appeals being filed before the ASBCA. ASBCA appeals have been trending towards a stronger success rate for contractors and small businesses. We'll point out that small business contractors are encouraged to consider expedited procedures, which are provided under the ASBCA rules when they are able to. And that essentially leaves a dollar amount. So any contractor is allowed to pursue expedited procedures when there's a certain dollar amount. So typically when the dispute is under $50,000, any contractor can pursue an expedited procedure if they so choose, which would guarantee a board decision within 120 days. For small businesses, it's under $150,000. So that cap is expanded for small businesses. So we typically encourage small businesses to at least consider that expedited procedure. There's also an accelerated procedure, which it's confusing that they use expedited and then accelerated, but that is when an amount in dispute is under $100,000 and it requires a board decision in 180 days. So a little bit longer than the expedited, but another good option for contractors.
Yeah, so just one really quick item to just touch on. So one of the things that our clients ask all the time is the fees incurred as far as litigation. If we're in an appeal posture, is that recoverable? So Equal Access to Justice Act does allow for fee recovery if successful at the Board of Contract Appeals or the Court of Federal Claims and you get a judgment in your favor. You do have to argue that you have to argue against the government, basically saying that their position was not substantially justified. So basically saying their COFD was not justified in its position. If you are successful there, you can recover fees. If you as an entity are under 7 million at the time of appeal, and your net worth is under 7 million at the time of appeal and you have less than 500 employees, but the legal fees are capped at $125 an hour. I know that sounds crazy, but that is the cap. So it is a significant reduction in fee recovery, but it is available to you if you are successful at the board or at the court and demonstrate that the government was not substantially justified in their position. So just one last thing to keep into account. And then from there is questions. I know that is a ton of information condensed into 45 minutes of speaking, but if anybody has any questions, John and I are happy to answer those.
Well, no, Lauren and John, really appreciate this. There's a lot of depth to this, and it's not always Really appreciate you taking time. And you're right, to be able to put all this into 45 minutes is not easy. So we definitely have time for Q&A. If you have any questions, please feel free to put it into the chat, and I'll definitely kick it off. Okay, so yeah, so in your experience, how successful are contractors at receiving equitable adjustments following an REA?
Sure. So, I mean, the level of success is driven by support, right? So when we have clients that come to us that are saying, you know, our REA, we submitted an REA, we haven't received a response, or the government's not agreeing to negotiate, the biggest problem that we see is really the evidentiary support. So, you know, sometimes we'll get like a one-page document from a client that they submitted. There's not any argument as to why or request for entitlement. It's really just here are our costs and asking for them to get paid. So what we do from there is we obviously help beef up that submission. That's with underlying cost support, right? Invoices, quotes, anything that really helps support their position. And then we also tell the story, right? Narrative is really important. And so one of the first things that we always ask for is a timeline of events. So we can tell the story to the contracting officer, basically how we got to where we are and why we've incurred this cost impact or time impact or both. So REAs can be successful, but there's obviously needs to be some form of argument as to entitlement and then also support as to cost or time. So in construction aspects, for instance, like John was talking about, the biggest trip up we see is really schedule impacts. So I saw somebody had asked a question about, you know, how do we see success with government agencies paying on REAs for long delays? Certainly do see success, but that is very much driven by schedule support. So we also have clients that may not have good in-house schedulers. We've seen, you know, oftentimes deficient scheduling. And so if that's the case, the government's not going to pay out costs associated with an extension, with a delay, even if driven by the government, if the schedule is not there to support and show, you know, impacts to the critical path, for instance. So all of this can be successful as long as you have the justification for it. So that, again, is extremely important to make sure that your ducks are in a row, that you're actively recording conversations you're having with the contracting officer, making sure that your schedule is being updated, that your accounting system is tracking these costs. And that's just going to put you in a much better position to be successful at the REA phase.
Yeah, I'll add with regards to the tracking of delays throughout the contract schedule. One key thing to pay attention to is the government's requirement for response times to submittals. So it's a good idea for contractors to be tracking dates in terms of when submittals were submitted and when that response ultimately came in and what impact that had on the project schedule. We've had a couple cases like that come up recently where there's significant delay on the side of the government in responding to submittals, which is holding up a critical path of the schedule. So whether including those dates in that time and that delay time in meeting minutes or daily logs, or some other means that's easy to track and provide evidence to that delay is a good idea as well.
So I would appreciate that breakdown. So if we discuss on appeals, so how long does an appeal before the ASBCA or CBCA typically take from filing of the notice of appeal to the board issuing the board issuing a decision?
Yeah, so it depends. Very lawyerly response there, but you know, if we end up having to go through protracted litigation, we're talking about a large claim that's covered, you know, multitude of years of dispute. That can take years. John and I have been working on a particular case like that. That just the depositions themselves have taken over a year to complete. So, you know, it is full-on litigation. You go from initial pleading process, just like you are in formal court if you're at the Board of Contract Appeals or even the Court of Federal Claims. Initial pleading, and you get right into discovery. That's discovery requests, that's depositions, that's production. So it is just like standard litigation. And we all know that, or at least John and I know that litigation can take quite some time. And then, you know, say you get to your hearing, right? Hearings can take 2-3 weeks to complete. And then even when you're done with the hearing, it can take over a year for a decision from the Court of Federal Claims or even from the Board of Contract Appeals. And that's just not also not including motions practice. So, sometimes you engage in motions practice where the parties are trying to dismiss portions of your claim or trying to get summary judgment on a particular matter, and then you have to wait for the board or the court to rule on that. So if you find yourselves in an appeal posture, you have to be ready for resolution to not come for some time. It can, like I said, it can take years. However, there are those off ramps that I was talking about earlier, right? That's the alternative dispute resolution processes. So, in certain cases, sometimes John and I are able to participate in mediation against agency reps where we're sitting in a room, we have an independent mediator sit in and help the parties reach a resolution. Another option is settlement. I mean, there's also instances where John and I prepared settlement offers, and we can start negotiating settlement early on in the process. But the only way that you can short circuit that protracted litigation is if agency counsel is also on board. It has to be voluntary. Both parties have to agree to participate. So yes, there are ways to shorten that length of time for resolution, but both parties have to be on board for that and be willing to engage in those alternative resolution processes.
Got it. I appreciate the breakdown. So you're right. It depends. Yeah, and so many dimensions to that. So I think this is definitely one top of mind for a lot is how challenging can it be to undo a termination for default?
Okay, so for challenging a termination for default, so the biggest point to make is that a termination for default is actually a government claim under the CDA. So the government is basically saying like you defaulted, and the reason why it's really considered a government claim is because they're actually entitled to reprocurement costs. So if that default sticks, the government has the right under the FAR to come after you for the difference of them reprocuring that work. So what will typically happen is they will issue you a notice of termination for default, which is a government claim. In that notice, they will give you your appeal rights. So you're actually right in litigation once that notice for default hits you. It will go in likely into your CPARs. It will also likely go into your SAM. And the problem with that is that you're really not afforded due process, at least from my perspective, because all this gets uploaded into the system and then you're starting to lose contracts while that default is on your record and while you're appealing it and challenging it. So as soon as a client reaches out to us, hey, we got a default, we are moving on that lightning fast because of the implications it can have on future bidding. So again, it's a government claim. The only way that you can challenge that is appealing it to the Board of Contract Appeals or to the Court of Federal Claims and jumping right into litigation. What we typically do, particularly for our small business clients, is we try to have a call immediately with agency counsel to basically say like, hey, we're dealing with a small business here. They can't afford to have this out on their SAM. They can't afford to have it out in the CPARs. Let's see if we can short circuit this process and reach some form of negotiation to convert this to a termination for convenience. Sometimes agency counsel is willing to have that conversation. Sometimes the contracting officer is frustrated with the situation, right? That maybe this is years down the line. There's been a lot of discussions, a lot of cure notices back and forth, show cause notices have been issued. And the contracting officer, who is the client from the agency's perspective, is just not willing to negotiate. They want to go through discovery. They actually do want to litigate and push back on their decision to default. They feel like that decision is justified. That can be challenging because you have to go through full litigation to try to get that default converted. And it can be extremely costly. The other issue that you can run into with a termination for default is if the default gets issued and you have claims and you haven't filed them yet. So what do? You actually have to submit your claims as and if you're raising those even as defenses. So let me back up a bit and provide an example. Clients doing a construction project, there's a lot of issues with the construction. There's a lot of disputes that arise between the parties. The contracting officer issues you a termination for default, but you have claims for delay. So from a contractor's perspective, you believe that the default is improper because the government's delayed you in multiple instances. What can you do then? You actually have to file a claim for those delays to actually properly raise those as defenses at the Board of Contract Appeals. So procedurally, it's a bit complicated, but we do it for clients all the time where we're appealing the notice for termination for default. We sometimes will seek a stay of that process to allow us to then file claims arguing delay so that we can then raise those defenses to the termination for default. Again, I know that sounds very complicated, and it is, but it's really the only way that you can get your defenses at the board or at the Court of Federal Claims to process appropriately. So it can be challenging to undo a termination for default, and it can be very expensive. So that's another thing to keep in mind, that it is not a cheap process, especially if you have to fully litigate and challenge a default. And if you are unsuccessful in challenging that default at the end of the decision, the government is going to go after those reprocurement costs. They are going to go after that difference between what they agreed to pay you and now what they're paying a subsequent contractor. And that can be a significant difference, right? That you had. So not only do you have this default on your record, but then you're paying the government to then pay this other contractor. So it's extremely harmful. It can prevent you from receiving future work. So ever more reason to take it seriously. And that's why I tell clients, like, as soon as you get a cure notice, if you start to get a sense that you're going to be receiving a termination for a default, that you engage counsel right away, because what you're starting to do at that cure notice phase is creating a record of defense for you as a company. And so it's really important that you engage counsel early on in that process, because you don't want to be making admissions in those responses. Like, we see a lot of clients that reach out to us later in the process and they send us their cure notice responses, and they've been making all these admissions like, yes, this is our fault, we're going to fix it, just allow us back on site. And the problem with that is when the government eventually defaults you and we're defending you in that case, and there's something on the record that says you admitted to doing the wrong thing, it's extremely hard for counsel to unwind that. So ever more reason to engage counsel early so that we can strategize an appropriate response to those cure notices, show cause notices, to either hopefully avoid a default, or if you do get a default, we're teed up with a solid record to challenge that decision by the contracting officer.
Yeah, along those, I'll just add in, along those same lines related to CPARs, be very careful as to the comments that are provided, contractor comments that are provided in response to negative CPARs. We would encourage that contractors kind of reach out to counsel before submitting those comments, because those go on record as well. And those CPARs and the narratives that are placed into those contractor comments and in negative CPARs often play a substantial role in those negotiations and discussions regarding terminations for defaults down the road. And we do have, there are different theories of conversion when it comes to those terminations for default. They can be converted to terminations for convenience when it's found that the government improperly terminated for default or terminated in bad faith. So the chances of success on these things are highly dependent on kind of the record that's set by the contractor. So the earlier you get counsel involved, likely the better outcome if that were to be the case.
So great. So we definitely need to close out. So, but Lauren and John, really appreciate your time. This is definitely very informative on this overall topic. But if anybody on here really would like to reach out more, if you have a question, their contact information is in here, and also the additional information will be forthcoming on our document delivery. But we do like to wrap up today's session. Really appreciate everybody joining us here today. And really appreciate the insights that everyone provided as well. But before we do wrap up our program today, I would like to share some of the upcoming events that we do have planned. So please mark your calendar for some of the upcoming local post events, as well as some of the national events as well. So do join us next month for our May 1st Friday webinar on Friday, May 8th, which is going to be the second Friday in May, from bland to grand, making winning presentations faster, which is going to be presented by Mike Parkinson at the 24-Hour Company. So join this webinar, how you can quickly transform complex ideas into clear, compelling presentations using proven frameworks, visual design, best practices, and practical insights on where AI can support your workflow. And if you are interested in presenting your knowledge on current educational topics for the First Friday series, we are accepting presentation abstracts for the fall 2026. So please visit our website to learn how you can submit your topics today. Just a few of the information on national events. The national election is underway. Help shape our future of society, and voting is open now until April 15th. Also, registration is open for the JETC this May in Portland, Oregon. Hotels are finishing up, and this is one SAME's technical training conference. So please go ahead and visit the website at samejetc.org. But the DC Post has a very busy calendar throughout April and May, from mentoring sessions at the Phillips Architectural Engineering and Construction High School. We are going to have a meetup at the Arlington National Cemetery as part of the America 250 celebration, as well as our joint APA and small business conference. So we have a very busy calendar. So come on join our website to see more and join us on our website. You can also look at all of our past First Friday webinar sessions on our YouTube channel as well. And if you'd like to reach a global community of more than 7,000 architecture, engineering, construction, technology leaders with the annual DC Post sponsorship, you have the opportunity to leverage our network to showcase your firm that you won't get anywhere else. You can sponsor annual sponsorship, program sponsorship, just like this First Friday series, or individual events. So check out all the benefits to support the mission of DC Post in your community today. So thank you again for attending this First Friday webinar series, and thank you, Lauren and John from Polero Mazza, for providing integral content today. If you haven't done so already, you can download today's documents before you leave the webinar, or just wait for the email with the subject line document delivery with your PDA certificate, opt-in list of registered participants today. And we will post this recording on our DC website later on this month. And you might also get a webinar email from our presenters with more information on what was presented today and how you could sign up for their newsletter and any announcements. So again, thank you to our DC Post First Friday sponsors, Fox Rothschild, JS Global, ETG, KCCT, Parsons, and Stantec. So on behalf of myself, Bree Beal, and Samantha Long, have a great holiday weekend, and we look forward to seeing you at the next SAME event. So thanks again.
Thank you, everyone.